Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about how do you make sure that you exclude or disinherit somebody from your will. Now, Virginia is a common law state, which means that your spouse and your children have a right to make a claim on your estate. They have a legal right to actually do that. However, you do have the right to disinherit them or exclude them from receiving property through your estate. Now, the most common areas of disinheritance we see what we call non-familiar members, extended family. The other option is disinheriting spouse, and then of course the last one's disinheriting children. The easiest of the disinheritance is the non-immediate family members. That means grandparents, siblings, nieces, nephews. As you extend out the family tree beyond your immediate family of your spouse and children, when you're dealing with the extended family, they have no legal right to claim on your estate outright. So you can just not list them in your will, and as long as you have other heirs at law, they won't receive anything. The only way they could receive something is if you die without a will, and then you don't have a spouse or any children to inherit from you, in which case the legislature has said that through the intestate laws, that they would possibly go to your parents first, then your siblings, and if not your siblings, then down to their children. Of course, that's only if you die without a will. If you have a will and you specifically name beneficiaries, then the parents, grandparents, siblings, extended family have no legal right to claim. Now, if you're going to disinherit your spouse, you do have the right to do that. However, the Virginia legislature has made it a public policy issue that if you're going to disinherit the spouse, your spouse has been married to you, has a legal claim to your estate, your spouse has 6 months to contest that. If they file a claim on your estate within 6 months of your passing, then your will be overridden and your spouse will have a right to claim between 1/3 to 1/2 of your estate, depending on your family situation. However, if your spouse does not file that claim within 6 months, then that claim is extinguished and your will go into effect and your spouse will be disinherited and receive nothing. If you're looking to disinherit your children, it's very similar to the spouse. Your children have a legal right to claim against you. However, if you specifically name your child and to disinherit them, then they will be disinherited from the will. Now, you need to specifically name them in your will as being disinherited or excluded. If you simply don't put their name in the will and you name your other children in the will, that child could make a legal claim saying, hey, I was just overlooked. It was a Scribner's error, as they would say. My parent meant to include me, they just kind of forgot. And they can make that legal claim before the court, and the court could actually rule in favor of the child. Now, of course, the child is going to need to present some evidence to try to establish that claim. But there is that possibility that their claim will be successful and they'll be able to inherit from you. However, if you specifically name them in the will and say, I am disinheriting child A, then they will not be able to claim under the will. If you wish to disinherit either extended family, your spouse, or a child, then you really should speak with an attorney to make sure that you're doing the disinheritance properly and that the will is properly executed. If it's not properly drafted and executed, then the child can contest the will and possibly have the will returned and then be able to inherit through the intestate laws. If you have any questions about how to make sure that you can disinherit either a spouse or child or extended family members, reach out to the Johnson Law Firm. We'd be happy to answer those questions for you.